Hi everybody, this is Jeff Fowler with the Apartment Owners Association, and again it's great to have you with us today. And wow, today we have 5 questions for a famous attorney in the San Diego area, and so you're in for a treat. And then also you do get to ask questions. Actually, I have 4 questions, and I'm trusting that you'll have a question as well, and I already see that there are questions up there. And anyway, AOA is the largest individually organized group of apartment owners here in the state of California, and specifically in San Diego, we have Victoria on the phones as our property management advice hotline, and you can always give her a call. We have the forms, the magazine, and if you're not a member, you sign up in your first year, if you're not happy with it, full money-back guarantee, no questions asked, except, hey, what could we have done better so that we could improve? And anyway, just definitely want to welcome you. And the reason that we exist is because we've made it our goal to have the most successful group of apartment owners in the state. So everything that we do revolves around that goal, and just keeping you in the know, giving you just information that's going to help your property management process be streamlined and more efficient. And anyway, so that's what we're all about. And tenant screening, I believe today we're going to have the previous address history going back in. We had planned that for last week, and we had some. Yeah, anyway, so there were issues that came up just with just here at home, and anyway, we had a tough time with our, I won't go into it, but here we are, and so that will happen today or tomorrow, and that will be included in all of the combinations that have at least a criminal report in it. And so that previous address history, so valuable, and we've been waiting to get that thing back in there. So we're excited about that. And let's see, you may have missed, we did have a property rights roundtable last month, and you may have missed it, but you don't have to miss the next one. And it's April 12th that's coming up. So definitely check that one out, and just check our events page. There's all kinds of events that we're doing all the time. If you're not watching on YouTube, or if you weren't aware, on YouTube, if you search AOA USA, we have a lot of videos listed there. And we also have those videos plus a few others in the member portal. In the member portal, one of the ones that we have there's a series. We did a 3-part series on common building code violations, and so just to keep up with California building code, no matter what part of the state you're in, that code's the same. And so just being aware of what those common things are, it gives you eyes to see what's going on in your property, and hopefully you're probably already taking care of it, because that's the kind of members that we have. And anyway, but it's a great series for you to watch, and you can get that. You can only access that when you log into your member account, and that series is really exclusive to AOA. The guy that did that set up a code enforcement program in Los Angeles. Just decades of experience distilled into 3 videos, and I want to encourage you to watch it, because I think that this is an area, as they assault apartment owners, this is one of those areas that the assault can come from, and so we want you guys to be in the know and just totally compliant. So anyway. All right, so here we go. We're going to get into this. And our speaker today, he's been a resident of San Diego since 1970. He got his bachelor's, he got his MBA, his JD, all from the University of San Diego. He's been an adjunct professor there for at least 21 years. And he has founded a Landlord Legal Center. He has over 20 years of experience in landlord-tenant legal matters, and they do real estate contract law and resolution of contract disputes. And so it's my pleasure to introduce to you today Franco Simone, and we're going to get started. All right, Franco, here we go. There
Hi,
you
how
are.
are you?
I'm doing great. How have you been?
I've been great, hanging in there.
Okay. Well, yeah, again, thank you so much for doing this. And it was great to see you, by the way, in San Diego at that last property rights meeting. And I just appreciate being able to work with somebody that shares the same values and that cares for real estate investors the way that you do.
I was glad to be there. I think it was a great meeting with all the other participants there, and I was glad to be a part of it.
Right. And some of the stuff that you shared was, like I knew there were things going on. And so I've incorporated even some of what you shared into some of these questions here. But I hear there's a new tenant rights ordinance that's in the works in San Diego. And what new controls are they considering? How do you think that will impact both renters and owners? If you could go into that, that'd be great.
Sure. So the city of San Diego has been working under what's called the Tenants Right to Know Act for quite a few years now. And so I believe it was December 6th of 2022, the city issued proposed new legislation that they might enact. And so they did a press release. So pursuant to that, they wanted to get the public's feedback on these new requirements, which basically affect the relationship between landlords and tenants. So I can briefly go over them so you can kind of understand what they're kind of looking at. Under the Tenants Right to Know Act, that wouldn't take effect until you are a tenant for 2 years. So in this new proposed regulation, they wanted to take effect day one. So as soon as you have a tenant, the first day that they're in there, they have the full protections of the Tenants Right to Know Act. And just so everybody knows, the Tenants Right to Know Act is something that's specific to the city of San Diego. They don't fall under what's called the AB 1482 law, which applies to other states because the Tenants Right to Know Act was voted in prior to the state's regulations. And so pursuant to the state act, the city of San Diego Ordinance Right to Know Act is what operates in the city of San Diego.
Recording in progress.
Okay. Well, excuse us. We had a internet disruption and that kicked us off there, and we're back again. And so not sure really where everything happened. So let's just start all over again with that question about the tenant rights ordinance that San Diego City Council is thinking of passing.
Sure. So the additional restrictions, if it's a no fault termination notice, meaning the tenant didn't do anything wrong, and let's say the landlord wants to take the unit off the market, off the rental market, the new proposed legislation will require the landlord to pay the tenant 6 months relocation benefits, which is a lot, right? So that's basically a half a year. If the owner wanted to move into the premises or one of the owner's family members, then that would require 3 months relocation benefits. And also part of this proposed legislation is that the landlord would have to give the city of San Diego notice that they're doing this to this particular tenant. So that's for no fault. The changes to the fault evictions, which is basically, or fault termination, which means that the tenant did something wrong. And so that's the reason why, the landlord's kicking them out. It could be a breach of lease, failure to pay rent, those type of things. They want to remove or they want to modify one of the reasons, which is illegal use. Sometimes tenants use their tenancy for an illegal purpose, selling drugs, prostitution, selling things from their apartment that they're not supposed to be selling, anything that might be illegal from the unit. They want to restrict that as a reason to terminate a tenancy unless the tenant's actually been convicted of that crime. So if you suspect that the tenant's dealing drugs, you have traffic all day, all night. In the past, you could use that reason that they're doing something illegal, they're selling drugs, but now you wouldn't be able to do it unless they were actually arrested and convicted. So I'm not sure how that's really going to help anyone. I think what's going to happen is tenants that are selling drugs are basically going to keep selling drugs, and to get a conviction, it might take 1, 2, 3 years to make that happen. And in the meantime, the landlord, as well as all the other tenants that live in that particular apartment complex have to suffer through a person that's doing some illegal activity. So I don't think that's a good reason. It's just basically going to cause havoc with all the other tenants. And I hope that requirement doesn't become part of the law. The other thing that they want to modify, actually withdraw from the fault termination, is currently, if the tenant's refusing to sign a new lease or renew the lease, then you can use that as a reason to kick them out. They want to remove that completely. So that wouldn't be a reason. So if you go to your tenant, let's say your tenant's been there 10 years, you want to update your lease, add new things, you send them the lease, it's basically similar terms, you're trying to update it, and they refuse to sign it, then you can't use that as a reason anymore on this new proposed legislation to force them out. So I don't know why the city's doing that. The laws are changing continuously. The landlord, sometimes needs to update their leases. And I don't know why a tenant couldn't just sign an updated lease, assuming all the other terms are similar, meaning your rent's the same, your security deposit is the same, and the landlord's just trying to update things. So I think that's also a very bad idea. Also, another part of this proposed legislation, and I'm trying to hit on just the main points and not every single point.
Yeah.
It will give the tenant more time to cure any potential default. So let's say the tenant currently most breaches are resolved by giving the tenant a 3-day notice. Let's say 3-day notice to pay rent, a 3-day notice to perform covenant or quit. Those type of things. They want to increase that to 7 days. So it would just give the tenant more time to try to pay the rent, stop doing whatever they're not supposed to be doing under the rental agreement. Again, I don't know why they need 7 days. If a tenant is illegally subletting the premises to other people, they shouldn't have done that. I don't know why it takes 7 days to ask people to leave. If the tenant is illegally repairing their car in the back parking lot and they shouldn't be doing that, why does it take 7 days for them to stop repairing cars in the back? So again, this is, little tweaks that's just making it more difficult for landlords to enforce their rights under lease. And, the rights under lease is there not only for the landlord to make sure that certain activities don't happen on the premises, but it's also to protect and serve the other tenants on the premises, right? So if somebody's doing something, let's say repairing their cars or other people's cars in the back lot, and maybe they're taking up more parking spaces than they should be, or they're causing a mess by oil spilling everywhere, that affects all the other tenants. And so by restricting a landlord to kind of control what happens on the apartment complex, it's going to affect the other tenants. So again, I think this isn't really an improvement. It's actually a detriment to not only landlords, but also other tenants that just want to live in a clean, safe place. So that's typically the changes that they want to make to the San Diego Right to Know Act.
Great. And, I did write a letter, and we're going to be getting that out in an email. And, it deals with some of those issues. And it also sounds like they want to create a bureaucracy, generate income somehow to pay for a big old bureaucracy that will manage and help both tenants and landlords, which is like, roll your eyes, right?
Yeah, it's unfortunate. All these types of restrictions, these rent control measures, these things to make it to kind of piecemeal control the relationship between landlords and tenants has been done before. It's been attempted before. Back in the 60s, 70s, or even during World War II, the governments come in, and the only effect that it has, it basically drives up rents. It dries up potential new construction because people, they have more restrictions on landlord. The landlord has to jump through more hoops, and so it becomes more costly to have tenants. They have to shift that cost somewhere, and typically gets cost to the tenant. If it becomes too restricted, all these new laws, if a developer out there says, I want to build some units, I can go to San Diego, but they have a really strong restrictive law, or I can build these units in Austin, or I can build them in Phoenix. They're going to move their money to these other places where there's less restrictions, where they're going to be more likelihood to have a landlord who's willing to buy those properties or build those properties and manage them, because they know they have a little bit more free reign on making sure that the units are safe for everybody living at the complexes. So it's been done before. They got to the point, like in the 70s, 80s, they would have these projects. I don't know if you remember those out in New York, basically government run units, 100% controlled by the government. And they were a complete failure. So every step we take with these new laws, you're just making the government take over the whole rental industry, with the end point of, well, are we going to go back to those project days in the 70s where the government was 100% landlord, and those failed miserably? Yeah. They were failed miserably. I think the better tack to take is like they do now with Section 8. Section 8, basically, the government basically comes in within the free market and pays a portion of the rent for the tenant. That's where the city of San Diego should be going. Not making more restrictions, but saying, what? These tenants are having a hard time paying the rent. Why don't we set up some type of funding like they did during COVID, and have more people that are like, look, well, you're down on your luck, and you lost your job. We'll pay for 20 or 30% of your rent. This doesn't cause the distortions in the rental market that all these new laws currently do. And so that's where the city of San Diego, I think that's where the state of California should be going, taking their hands off, helping the tenants directly, and let landlords do what they do best, provide housing for tenants. And let's not get the government what they do worse, managing housing for people, because we've done it before and it didn't work. So I think they need to take that approach as opposed to keep adding on these new regulations, because these regulations are costly. It's going to affect what could be built in the future. But eventually, well, unfortunately, they might need to relearn this lesson all over again. But in the end, who gets hurt by this? The tenants do.
That's
the
right.
tenants that they're trying to help, it hurts them. The other tenants that have to bear, let's say the bad behavior of other tenants, and the landlord really can't kick that person out or is restricted on kicking that person out, they get affected as well. And so, it's going to end up with higher rents, less production of housing units. But,
Yeah, and that's where we're at. And I think that's a good point, they need to connect the dots, because it's pretty simple. The fewer units you're creating, whether it's rental units or regular, then that just means that the price is going to go up. And when they create that kind of environment, it creates uncertainty, and you end up going, like you said, you just build them in Arizona. A lot of people are moving there anyway, right? So what about the current court situation? What can you tell us about that?
Sure. I think I spoke on this last time we talked, but it's been a real mess with the court lately. The court is very behind on processing paperwork. Unfortunately, after the courts were kind of opened up in April 1st, 2022, is when the first time you could start an eviction on a tenant that failed to pay rent. So we had a lot of cases where the tenant didn't pay rent for a year and a half, 2 years. The landlord was restricted on filing an eviction to kick them out. And eventually in April, they were able to do that. It was a huge burden for a lot of the housing providers to go for a year and a half, 2 years, not collecting rent. And so there was a big bulge of cases that were filed in April 2022. Unfortunately, a lot of the clerks in the clerk's office didn't come back after COVID. They had to hire a bunch of new people. And the fact that they had new people, plus there was numerous, I think the last count I looked, I think there's 17 or 18 new laws that have passed since COVID hit, state, federal, county, city, court. And so these 18 laws, they need to be digested by the court. New forms need to be made up, and people just don't know how to handle cases anymore. So you have the new people plus all these new laws. It just became a nightmare. Everything came to a grinding halt, basically. Right now, we're still dealing with a huge backlog. The clerk's office is slowly catching up. I would say they're probably a couple of months behind on paperwork. Unfortunately, we only have one department for the whole San Diego County. All 4 or 5 million of us in San Diego County just has one department that handles evictions, which is heard in downtown San Diego. In the past, I don't know if people knew, we had a department in El Cajon, we had a department in Chula Vista, we had a department downtown, and a department in Vista. We had 4 different courtrooms that handled evictions in the various locations. Now we're reduced to one department in front of one judge, and I think it's just too much for that one department. Typically, they'll have 15 to 20 trials every morning and every afternoon. I think that the the presiding judge really needs to hire additional help. It's not fair to Judge Bell, who's currently in Department 501 that handles all these matters. It's not fair to him that he has such a huge volume of cases. They should probably set up another 1 or 2 judges to handle these volumes because people aren't having their matter heard in a timely manner. Unlawful detainers, and a lot of people might not know this, are basically have priority over any other case. So the legislature set that up because they knew that the landlord, the housing provider, is suffering every day that they can't get possession back. They're not getting rent, but they're stuck paying the property tax, the water bill, the maintenance, etc. And so they wanted these matters to be on an expedited basis so that the market could be a little bit more fluid, of the landlord not being stuck in a position where he has no income coming in and he's basically spending a lot of money going out. So if it's a case between a murder case and an unlawful detainer, the unlawful detainer takes precedent, right? Because they wanted to handle these things in a quick manner. That's not happening anymore. Prior to COVID, unlawful detainer matters probably would last about 2 to 3 months. Now they're lasting about 8, 9, 10 months.
So a contested case is going 8, 9, 10 months.
10 months. Right.
And what if it's a case where it's just they don't show up? If
it's a case where the defendants do not file an answer and it's a default, you're probably still running about 4 to 5 months.
Wow.
In the past, it would have been a month and a half. So this is really having a detrimental effect because it's not freeing up units. So that unit is clogged up. The landlord's not getting any type of rent. The tenant's there for 8 or 9 months, and it's not until eventually they get removed that a new tenant can move in. So it's really affecting what units are available to other people that want to come into San Diego and rent. So, they're slowly trying to improve on the situation, but it's still very backed up. And one of the problems I'm backing up, besides the clerk's office, is there is just one judge, Judge Bell, currently, and he just has a crushing load on him. A lot of times he needs to sign a lot of paperwork, and so if he's in court all day long from 8:30 to 5 o'clock, I just don't know when he has time to sit down and do the paperwork that he needs to do to get it processed. So even though the clerk might be catching up a little bit on their paperwork and they're behind maybe 1 or 2 months, they could send things off to Judge Bell, but then it sits in his department for a long time because he's just overworked. So, for a county this big, state of California, we should have multiple judges handling this crushing load, because it's not fair to defendants or the housing providers that, it's taking so long.
Right. So how can we help Judge Bell? How can we help this system? Who do we talk to? Who do we write an email to or call up to see this change? What's something we could do practically?
Well, the downtown courthouse is basically run by the presiding judge.
Okay.
He's the Honorable Michael T. Smythe, Smyth. He's at 330 West Broadway, San Diego, California, 92101. That's the address of the courthouse. And his phone number is 619-844-2100. So that's 619-844-2100. The Honorable Presiding Judge Michael Smythe, Smyth, at 330 West Broadway, San Diego, California, 92101. Now, the presiding judge's job is to basically manage the courthouse. Mm-hmm. So he'll do assignments of who gets what, how they're going to handle the cases. So he would be the appropriate person to say, hey, what can we do to lighten up the load for Judge Bell and make sure that some of these cases are, proceeding at a reasonable rate. So that's where I would reach you. And that's where I've been kind of sending my clients that are a little upset about why is this taking so long? Because not only me, but all the attorneys are just basically waiting around a lot, waiting for the paperwork to be processed. We submit paperwork in the past. It might have taken 1 or 2 days to process. Now it's taking 2 or 3 months. I think that's just a little bit too much.
Yeah, absolutely. And that's just, how can there be justice? If it's delayed justice is really not much justice at all, if you think about it.
That's right. That's exactly right.
Wow. And all right. So Chula Vista laws, they've been in effect now for a little while. How do you see that affecting landlords?
Okay. So you're referring to the Chula Vista Residential Tenant Protection Ordinance. Mm-hmm. So that was passed, I want to say the end of December 2022. It became effective March 1st, 2023. So about 23 days ago. It's very similar to the state law and the San Diego Tenants Right to Know Act, but it's a little bit, well, not a little bit, it's a lot more restrictive, unfortunately, for Chula Vista. Again, we're going to have the situation where, well, the law down in Chula Vista is a lot more restrictive than, let's say, the law in San Diego or the law in Solana Beach or the law in Imperial Beach. If you were going to build some units, where would you build them? Would you build them in a place like Chula Vista, where it's very restrictive on what you can do and what you can't do? Or we build it somewhere where it's a little bit more, relaxed. Of course, they're going to build it somewhere where it's a little bit more relaxed. But let's go over the law real quick. If the law excludes certain properties, okay, it excludes single-family homes, it excludes duplexes where the owner lives in one of the duplex, okay, and for the single-family home, it's got to be owned. It cannot be owned by a REIT, a real estate investment trust. It can't be owned by a corporation. And if it's owned by an LLC, the managing member can't be a corporation. So what that means is if you have a single family home that's owned by a REIT, you're covered by the law. Okay. Mm-hmm. If it's a corporation that owns a property, you're covered by the law. You're bound to it. But if you own it in your own name, in the name of your trust, in the name of an LLC, and there is no corporate member, then you can be exempt if it's a single family home. Obviously, if it's a triplex, fourplex, how many other units, you're going to be bound by this new law. So the law does a couple new things. There's the important ones is there's certain notices you need it to serve to your tenants by March 1st, 2023. So this is very interesting. So the law took effect March 1st, 2023, and by March 1st, 2023, you were supposed to do certain notices, but those notices weren't required under the law until March 1st, 2023. So I'm not quite sure how that was supposed to work. But if you're exempt from this law, you're supposed to give notice to your tenants by March 1st, 2023. After March 1st, 2023, if you enter into a contract, a rental contract has to have that exemption notice in there. Okay, so that's one notice. The other notice is if the law applies to you, you are supposed to serve all of your tenants another notice basically saying that the law applies to them and that certain rent control laws are in effect. So that should have been served to all the tenants in Chula Vista on March 1st, 2023. Any new rental contracts that you enter into, let's say you have a new tenant right now, it should be part of your rental agreement. So I know a lot of housing providers have not served this notice yet. They should try to do it as soon as possible, reach out to their attorneys and figure out what that notice says, but what's the language. And I'm sure the various law offices can provide you with that, or you can always reach out to us at the Landlord Legal Center and we can provide that to you. So under the law, there's a couple of things also in reference to for no fault evictions. Basically, whether it be a 30-day or 60-day notice, you have to include new language in your notices. So your old notices won't work anymore. So you have to give those new notice. Then you also have to give notice to the city. So the city now needs to be aware of what you're doing with your tenant. So again, you're building up this new bureaucracy for the city of Chula Vista where they're going to start receiving these notices. Hey, I just served a 60-day notice on my tenant because I want to, let's say, move into the property or substantially remodel or do whatever they need to do. If you want to, if it's a no fault notice, then you're required to pay 2 months relocation benefits. And if they're elderly, meaning they're over 62, you have to give them a 3 months relocation benefits. Here's the kicker. This is on top of any relocation benefits that are required under the state. So if the state requires you need to pay a month, 2 months, whatever it is, you add that on top of the 2 or 3 months that's required under the Chula Vista ordinance. So you might be paying 3, 4, 5 months, depending on how old the person is and what you're trying to do, because you had the Chula Vista relocation benefits, you had the state relocation benefits, and any other law that might require other benefits, like federal law, you have to add all those together to give that to the tenant. Also part of this new regulation is you're not allowed to quote unquote harass the tenant, which basically means you're trying to basically intimidate them and somehow into moving out earlier or attempt to influence them to move out through fraud or coercion. You know, that's a fine line. If you're a housing provider and you serve a notice, hey, look, you haven't paid your rent. Is that intimidation? Mm-hmm. You send an email, hey, when can you pay the rent? Is that coercion? A 3-day notice to pay rent or quit basically says pay the rent or leave. You're basically telling them, if you're going to stay, pay the rent. If you're not going to stay, I want you to leave. Well, is that intimidation? Is that coercion? And I'm not sure how that's going to mesh with the landlord's right to ask for rent. They have a legal right to ask for certain things to be done. Don't breach my lease. Don't be a nuisance. They have their free speech rights as well. And so it's very vague what intimidation or coercion means. And they don't have any examples of what exactly that's going to look like. So I'm a little concerned about that and what's going to happen there. Let's see. Also, the other things that's part of this agreement is there's an attorney's fees clause. It's part of this agreement. So if the tenant feels like they've been coerced or intimidated, they could file a lawsuit against the housing provider. If they believe that the landlord violated this law, they could sue the landlord. They can also use it as an affirmative defense to any unlawful detainer, any eviction. And so what the problem with that is, I anticipate there's going to be a lot of new litigation, tenants suing landlords. And the other problem with that is, part of the Chula Vista ordinance, any violation, you could be subject to anywhere between $2,000 to $5,000 per violation per day. So let's say you didn't give out your notice and you gave it out 20 days late. I'm not sure how the judge is going to read this, but let's say you have four units. Well, that's 44 units. You were late 20 days. So 4 times 20 is 80. So you have 80 violations. And if you get $2,000 per violation, does a housing provider need to pay the tenants $160,000 because they failed to give a notice out that by March 1st, 2023, that wasn't required until March 1st, 2023? So this is a complete nightmare. It's going to open up the floodgates to litigation. And again, what's the ultimate effect of all this is going to be? It's going to ultimately harm the tenants, right? It's going to drive up costs. A landlord is going to be less likely to not ask for the full amount of rent increases that they want every year, because they might be afraid, look, I might be subject to this act and pay $20,000 for violations plus somebody's attorney's fees. And so I got to make sure I get enough rent to cover myself in case I accidentally violate this new law. So, I think it's just not good. They also increased the notice to cure. So right now, let's say somebody's repairing their cars in the back lot and they're not supposed to. Typically, you would just serve them a notice a 3-day notice to perform. Now you would, in any situation where there's a possibility to cure, you give a notice first to cure. Hey, here's your notice to cure it. Then if they don't cure it, then you give them a notice to quit. So basically adds an extra notice that you're required to give whenever the tenant does something wrong. So again, it gives, instead of one notice, you have to now serve 2 notices, and it gives them more time, more dates, more days to correct violations. And again, drive up the costs of what's going on. So the Chula Vista is a lot more restrictive than the state law, a lot more restrictive than the San Diego law. And again, I think ultimately it's going to come down to no new units are going to be built in Chula Vista. Again, why take on this tremendous amount of burden and restrictiveness, and why open up yourself to massive liability when you don't have to? Again, Chula Vista, if they want to help tenants, I would recommend doing what the federal government does and say, look, we'll help you with rental assistance. We'll pay you a certain amount of your rent so you can afford the rent. And that helps the landlord, the housing provider, make sure they have enough money to pay the expenses. It doesn't drive up the housing provider's costs to maintain a safe, clean environment for the tenants. And that's where we should be going. But Chula Vista's furthest along down the path of government taking over rental housing, and it's going to have disastrous effects.
100% agree. And yeah, thank you for just sharing all of that. We can get right into questions. And one of the questions was, do you have an email address? You gave us the address, you gave us the phone number. Do you have an email for Judge Smith?
I don't have an email for Judge Smith.
Okay.
I don't know if they would provide that.
Right. So give them a call and see if they have something. They may have an email if you give them a call.
And they can always try to reach out and go to the court's website. They might have an email address for the presiding judge.
Great. All right. Let's see here. Pull up the questions. Okay, Dave on YouTube. Renewing a 1-year lease with a good tenant, would it be better to go month to month? We'll raise the rent 10%, but that's still under market now in Imperial Beach.
I would recommend going month to month. Typically, freezing the terms of a lease typically benefits the tenant. If the rental market wasn't, if the rental market didn't have a lot of demand, then that's when landlords usually want to do 1-year leases, because they would be afraid, well, this tenant might find a better deal down the street, move, and then I'll be stuck re-renting it. By having the tenant sign a 1-year lease, then they're there for at least 1 year. But when the rental market is tight, there's no benefit to the landlord. Because what are the chances that a tenant, once he's in a unit, finding another unit that's going to be cheaper? He's not going to, right? Because like in this case, he's already below rent. And what are the chances of him actually finding another place? Very low, because there just isn't enough places. But what it does do, if you lock it in for a year, the landlord's locked in for a year, right? And so, as good as some rental agreements are, they don't cover every possible situation that might arise. And so the tenant might be doing something that's not part of your rental agreement that you don't agree with. And so, it gives you a little bit more flexibility, especially if you're within that first year, assuming, this new San Diego law doesn't pass. Imperial Beach does not have its own city ordinance. And so if you had a rental agreement that's less than 1 year, you could serve a 30-day notice to vacate and not have to state a reason, as long as the reason why you're kicking out the person isn't an illegal reason. That makes sense? So as long as let's say the tenant is cussing out people, cussing out your maintenance person, just being just unagreeable and making it very difficult for the landlord to do certain things, that doesn't fit neatly in anything in a lease. But if he's really being that disruptive with your maintenance crew or with you, then you can say, this isn't working out. It's been less than a year. Here's your 30-day notice. So it just adds more flexibility on behalf of the landlord. Do a month-to-month agreement as opposed to extending a 1-year lease, because the benefits aren't there for the landlord.
Right, and you're not the first attorney to say that either. Even up in Los Angeles, attorneys are saying the same thing, and for that exact reason there. So, great point. All right, Mike on YouTube. Realistically, how long? Oh, someone found the email address. This stuff's just popping up here. So it's Michael Smith. The way that it was spelled was SMYTH at sdcourt.ca.gov. And so I'll say that one more time, and then hopefully we'll be able to put that in the more section. But Michael Smith with that Y instead of the I at SD, as in San Diego, sdcourt.ca.gov. So there you go. Thank you. As they're listening to our questions, they have more freedom to go Google it up. Okay, so thank you so much for that. And yeah, because I think we need to help Judge Bell out as we're helping ourselves as well. But I mean, my goodness, it's just not right. Okay, so here we go. Back to this question. Realistically, how long the eviction process is taking these days from serving the first notice to the sheriff visit? I have a 5-unit building in Chula Vista. So he's trying to figure out what's he going to be out of rent for how long. And
I would say if there's a default situation where the tenant does not file an answer, you're probably going to take 4 to 5 months. If they do file and you go to trial, it will probably take you 8 to 9 months under the current system right now. Hopefully it will improve over the next couple months, but that's what I'm kind of telling people right now. And the reason why it's lasting so long, I'll give you an example. Let's say you've had your trial and you're trying to get a writ of possession, which is instructions from the court to the sheriff to tell the sheriff to perform a lockout. It's taking 3 months to get that, right? That piece of paper. Now, once we get that writ and we have to give it to the sheriff's department, we turn it around in 1 day, right? We received it and we send the original documents to the sheriff's department. They're taking up to 35, 45, 60 days to do the lockout. So right there, just those 2 steps are 4 to 5 months. That doesn't include filing the action, serving the action, waiting the time period for the person to file an answer. And I'm not even including if the tenant files motions right? I'm not even including if the tenant files bankruptcy, tries to remove the case to federal court. All these other delay tactics could add an extra 1, 2, 3, 4, 5 months.
Mhm. It's hard to believe we're still living in America.
Well, these lessons were learned. They were learned in the 70s, 60s, 70s. New York, Chicago, LA. But we're not learning from history, and we're going down the path again of government being in total control of housing. That's where we're at.
Right. I really covered that in my letter. I really covered it. I even mentioned Cabrini Green, and there's even the what is it? The nonprofit housing. I mean, it's just like the public housing, and there's no success stories. So yeah. Anyway, here we go, Brian. Thank you for your question. I have a question regarding the relationship of the current Right to Know Act and AB 1482. The right to know protections don't kick in until the tenant has been there for 2 years, but AB 1482 starts protecting after 1 year of tenancy. Doesn't that mean that AB 1482 takes precedence since it is more restrictive and protective?
So the Tenants Right to Know Act, like I said earlier, was law before the state AB 1482. Okay. And when you look at whether or not law is more restrictive, you have to look at the total law. Okay. So you can't just pick one point and say, well, this is more restrictive than what the state law is. You have to look at everything. And also pursuant to the state law, it said, look, if there's a city out there that already has on its books certain laws dealing with these items, then those would take precedence over the state law. So I think it's pretty universal from the attorneys I know, as well as the judges, that we are, well, I know this is a fact. I mean, the court's rule is that the Tenants Right to Know Act is what is operates in the city of San Diego and not the state law. So that's what we need to follow. So you're right. The state is 1 year. The San Diego Right to Know is 2 years. But if they pass this new regulation, they're going to make it down to day 1.
All right, Laura on YouTube, are single family houses and townhouses still exempt? And I think they're asking about probably the San Diego City Ordinance, Right to Know Ordinance. What do you think?
Well, the city, the Tenants Right to Know Act applies to it applies to everybody. Okay, so you're not under the state law, so you're under city right to know law. So it would apply to single family homes. That makes sense?
Oh, okay.
The
Great.
just laws, the just cause eviction, the no fault eviction, all that applies to single family homes. There's exemptions under the state law, but we're not operating under the state law in the city of San Diego.
There we go. And there it is. We are not operating under the state law in the city of San Diego.
Right.
AB 1482 law. So there you go. That's definitive. It's got court case law to back it up, right?
Yeah. Well, I don't believe there's any actual cases that have been litigated, but the courts believe it so. The judges believe it so. And most attorneys view it that way as well. And what you have to follow is basically the judge believes, yes, the Tenant Right to Know Act, it presides or takes precedence, then that's what we got to follow. But you got to be careful. People that are listening, it's very easy to get tripped up. You're in Imperial Beach, or you're in Solana Beach, or you're in Lemon Grove, or you're some other city that might have an ordinance. You got to look at first to see if your city has an ordinance, what that ordinance says, what applies. Is it that ordinance or the state law? So we're just very specifically talking about City of San Diego. And what you really need to do, if you're not sure, you need to reach out to your attorney. I live in this particular city. What do I need to do? What do I not need to do? Because I'm afraid people are going to listen to me and say, well, Franco said X, and they apply it to some other city, and that city might not even be operating under the state law. They might have their own regulations, and then you have to look at those regulations. So it just made it a lot more complicated. And then on top of that, there's certain federal rules that apply to certain properties, right? So here's an example. If your property has a federally backed mortgage, then there's certain laws that apply to kicking out that tenant. So when we evaluate a case of, well, what laws apply to this particular house, we have to figure out, what type of property is it? Is it a house? Is it an apartment building, a duplex, triplex? What law applies? Is it a city law, a state law? What type of debt is on the property? Because does the federal laws kick in? So we have to ask a lot more questions than we used to in the past, just to figure out what laws apply to this particular type of rental.
Right. Right. And that's such a good warning for everybody. Thank you so much. Okay, Nancy. Hey, Nancy, how you doing? Is Imperial Beach included in the new Chula Vista laws?
No, Imperial Beach is a separate city. So currently they don't have their own ordinance.
Okay, Adventure on YouTube. Our 60-day notice is about to expire on April 1st. Do you have recommendations on how to get tenants out without an unlawful detainer? Tenants show no sign of moving out. Offer move-out assistance?
I'm not sure.
So they're just, I think they gave them a notice to move out, it sounds like. And so, but it doesn't look, they're not going to, it looks like they're just going to stay put. And so they see a lawsuit brewing here and they're just saying, hey, if it's going to be all of that, 5-6 months or more, what would you recommend to be able to just take care of this without having to go to court about it?
You need to make sure that your notice was correct. Mm-hmm. So what happens a lot of times these days are people are using old notices, serving the old notices, and then I eventually see it after the 60 days expire. And unfortunately, I tell a lot of clients, your notice is no good. The laws change, the language in the notice is different. And so before you serve a notice, you should really reach out to an attorney and say, I want to do X. How can I do it? And have them prepare the notice so you don't waste 2 months. But let's say the notice is correct. I mean, generally, I tell my clients, look, talk to the tenants. It is very disruptive to the tenants to move. And so if you give them a heads up, like, look, I'm thinking about moving back into my house, let's say, I want to give you sufficient time to move out. I'm willing to help you out a little bit. I'll give you 1 month relocation benefits, maybe 2. So talk to them, set up the dialogue for it. If you come to some agreement, then what I recommend to clients is have the tenant give you a notice that they're leaving. So let's say you agree with the tenant, say, look, the tenant says, I need literally 90 days to move, to find a new place. And the landlord says, okay, I'll give you 90 days to move. And I'm willing to give you, instead of 1 month, I'll give you 2 months relocation. So you don't have to pay your last 2 months. Then what I would do is like, look, tenant, give me a notice that you're vacating in 90 days, right? Now your contract might say, it has to be at least 30 days. So you're okay there. I will accept your 90-day notice. Okay. And then hopefully they move out because you kind of come to terms on how they're going to move out. Okay. Now, what I would do with the 2 months is maybe say, look, if they need the money, I'll give you 1 month up front, meaning you don't pay the rent. And the other month, I'll give it to you when you give me the keys. Right. Okay. But let's say they don't move out. I can base an unlawful detainer, the eviction, based on the tenant's notice to you. Right. And the tenant's notice to you doesn't have any restrictions on it. You don't have to jump through a bunch of hoops, right? It's just, hey, the tenant gave me a notice. I accepted the notice. Don't withdraw the notice down the line. Don't waive it. And so if they don't move out and do what they said they're going to do, then I can base the eviction on their notice to you. So try to work out something. Try to, if you have to, sweeten the pot a little bit. And then if you do come to some agreement, great. Tenant, you give me a notice as opposed to the landlord giving the tenant a notice. Because it makes it easier on me to move forward with the case. Because all I have to show is that the tenant gave you a notice that they're vacating. That's it. I don't have to jump through a million hoops of proving this, that, whatever. And so that's what I would recommend.
What are the key elements does that notice have to have a signature on it? What's needed there for it to really be accepted in court?
Nothing too fancy. Definitely put a date on it. Mm-hmm. And it's something to the effect of 1 or 2 sentences. I, Mr. Smith, and Mrs. Smith are going to be moving out on July 1st, 2023, right? And they sign it. Okay. That's it. I would confirm that you got the notice. Maybe email, whatever you want to do, a letter. Hey, Mr. and Mrs. Smith, I got your notice that you're vacating July 1st. That's fine with me, right? So acknowledge that you received it. Now, let's say the 90 days goes by And then on the 89th day, they're like, well, we don't want to move anymore. We withdraw your notice. I would send something back saying, no, I don't accept your withdrawal of your notice. Okay? So acknowledge that you got it. Don't waive it, and don't allow it to be withdrawn. So you have the right, once you've accepted, that both parties have to agree to its withdrawal. Okay?
There you go. Hey, thank you so much for answering those questions for us and just being available. And I always like reading your legal Q&A in the AOA magazine. It looks like we have one more question here that popped up all of a sudden. But excuse me, what were you going to say?
I was going to, I just came to my head under the Chula Vista law. Part of the law says when you're doing certain notices, you have to give notice to the city. The city of Chula Vista just recently, I believe last 1 or 2 days, actually published what that notice looks like. Before today or before last 1 or 2 days, we didn't have the notice. So even if you wanted to start an unlawful detainer, or the notice to kick somebody out in Chula Vista, you weren't able to serve notice on the city because they hadn't drafted the notice yet. So that just recently came out. So we're able to move forward now. It's like, okay, you want to do a notice? Okay, we'll draft a notice, and here we'll fill out this notice to the city. So you've completed what you're supposed to complete under Chula Vista law. Okay.
Cool. All right. There we go. So here's the last question. Okay, Francisco, are LLC recommended if I have multiple properties? Would a living trust suffice? How can I best protect my family?
Okay, so this is a great question, and I get this all the time, and it deals with liability. So a trust is not a separate legal entity. It's just a way of naming the property. So the trust doesn't own anything. The trustees, let's say Mr. and Mrs. Smith, they're the trustees of the trust, but the trust isn't a separate legal entity, meaning it doesn't give you any protection for liability. If somebody sues the trust, they're basically suing you as the trustees. With an LLC, it's a separate legal entity. So if you happen to get sued, if the LLC owns the property and you get sued, the LLC will get sued. And any damages that you need to pay out will be paid out of the LLC. So how does this work? If the LLC owns 10 properties, okay, and God forbid there's a fire on one of your properties and 3 people get seriously injured, right? They'll sue the LLC and they can go after all 10 properties that are assets of that LLC. That's not good. But let's say your LLC only had 1 property in it. If something catastrophic happens, and God forbid, and let's say it's above your insurance, right? Hey, I have $1 million policy. Hey, their medical bills are going to be $10 million over the next 40 years, right? Okay, they're gonna try to take your property. But if there's only 1 property in that LLC, the most they can take is that 1 property. Your other 9 properties are protected, right? Because the LLC doesn't own your other 9 properties. Also, your personal wages and other assets are also protected, right? Because the LLC doesn't have your stock account, doesn't have your income coming from your job. Now, as opposed to, let's say you own the property in your own name or in the name of the trust, and something catastrophic happens, right? Well, everything that's in your name, let's say you have all 10 properties in your name, they can go after all 10 properties. They can go after your income because that's your income. You're the owner. They can go after your stock account because that you own that stock account. So the way you limit liability is you just have the LLC, legal entity, own 1 property. So something bad happens, they just take that 1 property. So what most clients do, let's say they own 10 properties. I typically tell my clients, look, put at least $1 million equity in each LLC because there's costs to LLCs, right? You have to pay an $800 fee to the state every year. You have to do a tax return. That might cost $500, $1,000 every year. Do a tax return. So you're spending $1,800 a year to maintain this entity, which is okay. So, hey, I'm going to put this 1 property in there. I have $1 million equity in it. Okay, great. That's fine. Don't put 5 properties in there that have $10 million in equity. Does that make sense? Have 5 separate LLCs. Okay. So that's what people do is they set up LLCs for each property so they can shelter the properties in each LLC. The other thing I strongly recommend is if you have a lot of properties and you have an insurance policy of $1 million, it really doesn't cost that much to get an umbrella policy or to extend it. So that extra $2 million, 3 million is probably another $200, $300, $400, $500 a year. So $1 million like these days and age, a tenant gets injured, they're in the hospital for a week in intensive care, you've spent $1 million already, believe it or not. And so get that umbrella policy, get that additional insurance, and try to go up to 2, 3 million. It really doesn't cost that much money.
And if you have multiple LLCs, does it compound the insurance policy premium on that? What do you think?
Well, each property will have its own insurance policy, right?
Mm-hmm.
So the insurance company doesn't care who owns the property. So they just going to look at the number of units, where it's at, the condition, and the level of coverage. So they'll say, hey, $1 million is going to cost $1,500. If you want an extra 2 or 3 million coverage, it's going to be another $500 on top of that. And so that's how it would work.
Great. And AOA does have a like a group insurance, so you could call AOA, and we can help you out with that too. So,
yep.
All right. And then the Rusty, we thought this was the last question. Here we go. City of San Diego, and we will make this the last one. City of San Diego, 3-year tenant, owner's selling. What are the procedures?
City of San Diego, owner's selling. So they have to give you at least a 60-day notice. 60-day notice that they're taking the units. Well, is it a house or an apartment?
Let's assume it's an apartment.
Well, basically,
and Rusty, call Franco if it's not.
Well, basically, it's generally it's going to be a 60-day notice with 1 month relocation benefits, assuming it's City of San Diego. Again, if you're a tenant, talk to the landlord. Try to work out something with them. If you need a little bit more time, tell them, look, instead of 60, can I do 90 or 75 days? It's always better for everybody to make this smooth. So some tenants are like, well, no, I'm not going to move, even though they can. I'm going to make this as hard as possible. Well, you're kind of jeopardizing your credit, right? Because if the landlord ends up filing an eviction, ends up getting a judgment against you, now you have a judgment on your credit report. And right now things are extremely tight. If it's a choice between you having an eviction on your record and somebody who doesn't, the landlord's going to pick somebody who doesn't. So, it's better for everybody. Get your relocation benefits. If you need more time, talk to the landlord. Try to work something out. If you can move out earlier, say, hey, landlord, I can move out in 30 days. Are you willing to give me 2 months relocation? They might just go for it, right? Just so they can get the place back earlier. And so that would be something I would recommend as well.
Great. Well, hey, thank you so much. Again, we appreciate it. And for some of you, hopefully we'll see you on April 12th at the Property Rights Roundtable that we're going to have. And we are looking at coming up with a letter against for the city council, just to kind of let them know that we're serious about everything. So we'll see. We're in talks with an attorney at this point to write in a letter and send that over to the city council. So that's something that's in the works. Any parting thoughts, Franco?
I think the more everybody can get educated on this stuff, I think the better. Not only on the housing provider side, but also the tenant side. So I find if more people understand what their rights and duties are, I think the better it is for everybody. So I do encourage people to read articles, go on these podcasts, and find out what their rights are. And once everybody knows what their rights and duties are, it's easier to try to work out something where everybody kind of benefits from whatever's going to happen. So that's what I encourage people to do.
That's huge, huge, huge. All right. Well, thank you so much. Take care.
Hey, pleasure. Thank you.
Okay. We'll see you later.